Beginning in early November of this year, the Oromia region has witnessed a protest movement, the likes of which has not been seen in Ethiopian history. The protests were triggered by a decision to lease a sacred forest area to an investor around Ginchi, a small town west of the federal capital of Addis Ababa. Soon, the protest took on a form of resistance against the federal government's scheme known as the Addis Ababa Integrated Master Plan, but also merged grievances in rural areas with the urban issue of city expansion. In a few days, the protest movement engulfed all of Oromia and involved Oromos from all walks of life. The government responded with strong armed tactics that involved using the country's military against its own people. So far, more than 85 people have been killed, thousands brutalized, and tens of thousands imprisoned. The protests and government crackdown continues. To discuss these issues, we have invited Dr. Tsegaye Ragassa, a constitutional lawyer at the University of Melbourne in Australia, and Henok Gebissa, an international law fellow at Washington and Lee University in Lexington, Virginia. Welcome to the discussion. The first question that I have for you for our discussion is about the master plan. The master plan has not been officially released by the government of Ethiopia. Based on the information you both have, what is the master plan? Can you explain as best as you can what the master plan is? Why don't we start with you, Tsegaye?
Well, thank you. Indeed, there is very much of a confusion about what exactly the master plan is, because the kinds of documents that are issued in different forms, not officially, are here and there distributed, but no one for sure knows the official document that is the master plan. When it was revealed in 2014, the document that we could find was the list of some slides of a PowerPoint that was used for presentation in the training of the officials of the spatial zone in the area of which this master plan was to be implemented. But interestingly, the core of that master plan, the whole master plan thing, was incorporated in it because there were maps, there were statistics, there were different infrastructural sites, and so on. So for someone who would make some comments and statements about the master plan, and there was a statement of objective and so on. Recently, I found a document issued in June 2013. Here is what it says, the title. It's a very elaborate document, and someone sent it to me, and when they did send it to me, they said the master plan, the title of the document was the master plan booklet. And in that booklet, the title goes like this: Addis Ababa and the surrounding Oromia Spatial Zone Integrated Development Plan for Ethiopian Renaissance. That's a long title. And then in the middle of the page, there is this statement which says Addis Ababa and the surrounding Oromia Spatial Zone Integrated Development Plan 2014 to 2038. Draft Executive Summary. Now, this document, it looks to me, is probably the most comprehensive official statement of what the master plan is. It was issued, printed in 2013. It has got about, how many pages? Let's see, just a minute, please. About 65 pages. There is a statement, a quotation from the late Prime Minister Meles Zenawi in relation to the Renaissance. There is a message from the project officer, Ato Matthias Asfal. There was the project manager. There was a message from the mayor of the then mayor of Addis Ababa city, Abokuma Damaksa. And there are maps and all sorts of dispositions about the history and the future of the city and the surrounding area that are incorporated in this master plan. So what is it really in essence? In essence, this is a plan, as you can see, not an ordinary type of plan. A master plan of a city normally is developed for about 10 years, and it is bound to be revised every 10 years. But this one is rather unique because, as you can see, the title itself indicates that it is going to be a plan for 2014 and 2038. And in that little snippets of slides that we found in 2014, we also realize that the city's demographic setup will be completely changed. It makes a prediction about what the demography looks like in 2023, in 2033, and now 2038. So there is some kind of strategic approach to exactly what the document is. There is a deliberate hiding of what the document is, but there are also documents that are coming out from the offices, but without being said, this is the plan. So what does it do? Well, in our view, in the view of most Oromos, including the OPDO officials and the mayors of those small cities, towns, about 36 towns and 17 waradas surrounding the city, now which are the subject of this master plan. According to these people, the master plan simply incorporates these towns into the jurisdiction of what is now Addis Ababa. So that's basically what it is, and that has been interpreted by some as annexation, by others as simply a coordination of development of infrastructure along the points of conjunction. But be that as it may, for me, what I see is that Addis Ababa, as you know, is a very unnatural city. Although naturally it belongs to Oromia, it has been legally, through legal fiction, excised through a legal excision out of the jurisdiction of Oromia and has been made to be a city that self-governs and becomes a capital of Ethiopia. And to that extent, it has gone out of the administrative jurisdiction of Oromia. Now, the fact that this plan includes all these towns now, or extends to these towns in the name of integration of master plans, because normally if it is integration, the towns also have their own master plans and the city has its own master plan, and it will be a point of connection that we're talking about. But that's not what we see, because the towns didn't have any master plan. So from my point of view, the plan, by extending this grand plan into these towns and cities, fundamentally expands the realm of legally excised territory of Oromia, and incorporates these cities into the administration, into the government of Addis Ababa. So that's basically the core thing about the master plan. I think we can start the discussion from that.
The government says this is basically a coordination of the development efforts by both entities, the Addis Ababa City Administration and the Oromia City Regional Government. So it's a coordination. Is there any reason to doubt that this was really a coordinated effort to integrate the growth, economic growth and activities in both regions, Henok?
Yes, in fact, there is a strong statement that has to be made about this master plan, and my friend Tsegaye has tried to elaborate on the fictional value of the document, which is called the Integrated Master Plan. Before going directly through the doubtful opinions on the urbanization and economical aspect of this master plan, I would like to make small opinion or comment on what this master plan is. In fact, we all know that a majority of Oromo people saw the master plan as a grand political document secretly designed by the government to put an end to the economic and political influence and existence of the Oromo people in and around Addis. You can easily see that from the process and the content of the master plan itself. Even though there is no officially released document until today, we have a document which is widely circulated, which the government itself did not come out and refute that this is not the official master plan. So legally speaking, we are bound to take this document as an official master plan on which we can air our opinion. So having said that, including the fact that it is considered among the Oromos widely as a grand document to put an end to the economic presence and political presence of the Oromo in and out of Addis, the most important issue that needs to be scrutinized or studied about the master plan is that whether this master plan really expands urbanization or economic growth or a coordinated infrastructure development. This is a very important and critical point to be made. Number one, in my opinion, there is nothing developmental or economical about this master plan for so many obvious reasons. First of all, when we talk about development, we're talking about a sustainable principle of development, an inclusive and participatory kind of development and economic growth. When we see this master plan from the very point of its preparation, which was secretly done by a select few loyal group consultants from in and outside of Ethiopia who are very loyal to the government. When we see that, you can easily tell that the idea of the plan is simply to transfer and legally dispossess and dislocate the Oromo people from the land that they have rightfully lived on since time immemorial. So now, does the master plan stand the scrutiny of urbanization and economic growth? No, it does not. The reason is that development in principle encompasses and includes the people that you are trying to develop. If you have more than 6 million Oromo forced to be dislocated and dispossessed from the land, who are you trying to develop the land for? If it is a legitimate government, which in my opinion is not so legitimate anymore, what kind of development would be happening on the land with all those millions of Oromos forced to leave the land and then have their life reduced and diminished into the lowest social strata of being a guard and housemaid for a new settler who came under the name of investment? The Oromos were forced to be lowered one level of life of livelihood down from an organic and indigenous way of their life system into becoming a guard. So that really throws an opinion that the master plan would never stand the core principle of integrated urban growth and economic growth and sustainable development. So that is how I see the master plan. And in fact, the existing Oromo protest is a pro-democratic and a pro-developmental movement that is trying to tell the government that what you are doing is acutely and perfectly antithesis to what we call a development. That is how I see the economic and developmental implication of the master plan.
Obviously, the master plan has turned out to be a very controversial document. And you have pointed out the problems that are associated with the master plan. It's not only the legal constitutional issues that are in conflict, but the process itself that Henok alluded to. Is there anything else that you would add to Tsegaye about the process, the constitutionality of the process of the development of the master plan itself?
Yes, absolutely. Henok is right in pointing out the fact that the process is fundamentally flawed and the document is essentially a political document. Now, there is an attempt by the government to present the document as a technical development document, but there is really a lot of politics in it. In the recent discussion that one of the government-affiliated radio station had with Abadullah Gameda, they wanted to say that that because this is done by experts, it shouldn't be thrown away on populist grounds. And the Abadullah was very clear about the fact that they, in the service of democracy, they cannot necessarily implement a document just because it is made by experts. Now, let me make two, three strong preliminary points before I go into your questions. The first thing is that master plan, not just this one, but ordinary master plan that is done for a city and revised every 10 years. A master plan is a fundamentally political document. Wherever it is done, however it is done, it is fundamentally a political document, because urbanization has little that is natural about it. I mean, probably, yes, natural growth of a city, when the population grows, when the economic demand grows, etc., is there. But in our context, largely the growth of Addis Ababa city has come from urban-ward migration. It didn't come from internal demographic and economic dynamics. So it comes from which means then, whatever you do to prepare this urban space for people to make it habitable is a fundamentally politically driven process, which means especially more so because of the history of the city. Now, Addis Ababa city has nothing natural about its growth and its development process. It started with a fundamental inaugural violence as an occupied territory. The inaugural violence I'm talking about is the violence of dispossession and displacement in the late 19th century. And it is the result of the political economy of desire that always shows the march of desire following an imperial route. And therefore, the urban-ward migration historically has been from the north to the south. And now, it's always usually the movement is from the north, and then it started out as a garrison town. Now, because of this fundamental constitutive problem that it has, it is not a natural city. And as a result, whatever plan you make for this kind of city is not going to be a technical, economic, urban planning, etc. kind of document, kind of thing. What we are doing there is basically a political thing. So the master plan is fundamentally political, and if the politics is not right, then the technique cannot be right. If the political legitimacy is not there, then the technical legitimacy completely goes down the drain. Now, that's the first point I wanted to make. The second point is that it is presented as development, as Henok has pointed out, and I also pointed out this repeatedly in my many media stints and in my many writings on this subject for about a year now, that it is about growth of some type of economic habit, some kind of use and profiteering over land for particular groups. Now, I never thought that interest groups would influence politics this much in the context of Ethiopia. Now, one of the reasons why the governing regime has difficulty controlling this process, why it could not address it politically, is because there is the interest of special interest groups that are profiting from land and that are profiting from the historic violence that is done on the Oromo people, the indigenous Oromo people in that place, who have been invisible and whose land has been seen as a terra nullius, as a land, an open space. Now, what is happening then? It is obviously not development. It is a growth, all right, but a growth for particular economic interests of a particular type of a new cadre of economic elite in the country, which is also difficult and more intimidating to the regime in power. The talk between the exchange between Mimi, Sibhatu, and Abadullah shows you literally just that. The Speaker of the House of People's Representatives being told by a media mogul that technique is important, that populism is not important, that the attempt to condescend over him, to tell him what should be done, shows to you that somehow there is another origin to this. So it's not economic development, really. It is something else. If it were development, fundamentally one of the things that it does would be to respect the right to development as enshrined in the Constitution. Articles 43, 44, beginning from Article 41, we see socio-economic, cultural rights, and then we see the right to environment and the right to development in these areas, the last few articles of the human rights chapter. That was never taken account of So the urban plan, the master plan has nothing developmental about it, really. There is growth, there is basically justification of selfishness, a new capitalism that is privileged by the state, done and promoted by groups that are closely affiliated by the state. And in fact, the people on the ground also smell something else into it. There is a small collection of ethnically privileged group and so on and so forth. I wouldn't go into that level right now. The third point I wanted to make is that it is not integration at all. It talks about integrated development plan. Now, the plan is political. There is nothing developmental about it. There is a lot of dispossession. There is a lot of creation and production of artificial destitution. There is a lot of production, legal and political production of suffering, human suffering, Oromo suffering in this case. There is nothing developmental about it. And third point I make is that it is presented as integration. There is nothing integrating about it. I have a reason for saying that. The first is, if it were integration, you first recognize the autonomy and the independent existence, the relative independence, existence of those towns and villages from the city. You would expect that those towns have their own master plan. And it is those master plans that are going to be integrated at points of conjunction, at points where there is an interface between the city and the towns. Which means, if it were integration, there is an end to. There is a point where the city plan ends and the town's plans begin. But we don't see that. We haven't seen their plans, and we haven't seen them happily connecting with the great grand plan that is presented from the top. And in fact, it is the mayors and executive officials of these very towns and waradas who have been persistently objecting to the implementation of this plan. So having made these 3 points, let me also comment on the process. One of the arguments we presented in 2014, talking constitutionally about this master plan, is that each process, along with its content, along with the context in which it was implemented, along with the consequence of its implementation, each process is fundamentally flawed. Why do we say that? One, it is top-down in approach. Even forgetting federalism, forgetting local autonomy, forgetting all these complex dynamics that exists between Oromia and the city, Oromos and the city. Just the fact that it is made by some faceless people, really, faceless, nameless people whom we cannot take to account. The fact that it was secretly made and then brought out to the Oromia officials to be implemented and to be revealed only in that way when the Oromia officials resisted it. That is simply unacceptable, even in Lyon, in France, or any other city. So that's number one. Secondly, the process is flawed because, according to the Constitution of Ethiopia under Article 12, the Ethiopian government, and in fact government at all levels, legislative, executive, and judicial authorities, should behave in a manner that they are transparent in what they do, they are responsible, accountable in what they do. And by the mere fact that we didn't know about this office, and in fact now we are told that the office it doesn't exist anymore. The fact that we don't know who made the plan, the fact that we don't know whether the context, meaning the transplantation, the borrowing that is done from France, is appropriate for our context. All these things tell you that it is unconstitutional in terms of procedure. Number three, why is it that we say the process is flawed? Because according to the Ethiopian Constitution, Article 89, the political objectives principle, any government development project whenever it is done, whenever it is planned, it will be planned through a process of consultation, participation of the people who have a stake in that project. In our case, that didn't happen at the beginning, is not happening at the moment. For all the talk about the public discussions that EPRDF is saying that it is having, the public discussions, as we have seen, are places where the government presents it and convinces the people, not persuade, convinces the people, and in the process identifies those people who object to it and persecute them. So it wasn't discussed. It wasn't, let alone the public, even the officials didn't know about it. It wasn't the people weren't consulted about it. And people didn't know exactly what compensation is going to come to them if their land is taken away, what replacement is going to be possible for them, whether they accept the terms of displacement, etc. All these things have not been discussed, and people are unfamiliar with it. Hence, this explosive expression of anger that leads to what we see as the Oromo protest and what became an almost national movement right now.
So there are violations of specific provisions in the Constitution itself on many levels. Political, private interest, jurisdictional matters, processual matters. If I may ask you, Henok, and I think this is your area of scholarly interest, Article 40 talks about property rights. As a non-lawyer, when I read the document, personally I find the provisions under Article 40 a bit confusing as far as jurisdiction is concerned, especially with regard to land ownership. Can you enlighten us about individual rights of ownership and the protection against alienation, and the government's right to expropriate land in the interest of the public good? Particularly states' rights to expropriate land and grant it to investors. This is part of the Constitution, because as a non-lawyer, as I said, when I see arguments on both sides, both the defense and the criticisms of the master plan are based on the Constitution. So with regard to property rights, that is to say individual rights, the state's rights, federal rights, expropriationary rights, what would you say about the constitutional violations in that area?
Thank you very much, Dr. Ezkeil. First of all, I have to make a point that the Ethiopian constitution that came into being in 1995 made a provision of the law that the land belongs to a common property of people's nation, nationality of Ethiopia. We can agree or disagree on this particular provision, but again, we have to make sure that this same provision does not say that the land belongs to the elites and friends of a government. When the provision, especially Article 40 sub 3 of the Constitution, says that the land is the common property of nation, nationalities and the people of Ethiopia, it means that the central owners of this land are the people, and any kind of juridical act or inaction that has to be taken on this land will never happen without a full participation and consultation of the people that has lived on the land. Number one, the Constitution coming into existence in 1995 cannot ever override over the principle of land ownership tradition that had existed among the Oromo for thousands and thousands of years. Let's say that this particular provision of the Constitution gives the government the automatic or complete right to expropriate, even though there is a fundamental prerequisite for a valid expropriation to take place. It is really constitutionally and legally questionable, or remain a controversial issue if a document, a political document such as the Ethiopian Constitution, which in the mind of so many people is not really legitimate, can take away the traditional understanding of land ownership that had existed for over thousands and thousands of years. Now, having said that, you asked about the expropriation right of the government. Expropriation is not an automatic right of a government to take away land from the people who has lived on the land. There are three fundamental requirements, legal requirements for an expropriation to take place. Number one, the clause of public interest. Any kind of property, including land itself, might be expropriated if it is for the sake of the public interest. Now, let's define what the public interest is. The public interest here, in the case of the Oromo land, in and surrounding Addis, is the public interest and right to live a sustainable and in a way that really makes the Oromo people happy. They have been cultivating and growing the land for so long time, and that is the public interest. The public interest here includes to make and maintain the life of these people. So, in Ethiopian government's mind, to expropriate this property or this land of the Oromo, there is nothing that it can fulfill as a public interest of the Oromo people. It rather disintegrated and fragmented, or if we will, disenfranchise the Oromo livelihood. And that is a contrary view and perspective to what we can call a public interest. So expropriation in this situation is constitutionally and in any legal standard an invalid juridical act. So number two that we need to consider in evaluating the validity, the legal and constitutional validity of expropriation is that there is standard of compensation that has to take place, or a settlement between the people and the authority that expropriate the property. There is a compensation which in international customary law has been accepted by a wide number of countries. The principle of Hull formula, which propagates the idea that compensation should be effective, adequate, and prompt. Yeah. This is standard of compensation that emerged in the 1930s between the Latin American countries like Mexico and the United States, where the properties of some U.S. nationals who invested in Mexico were expropriated by the government of Mexico. And there was a famous statement made by the Secretary of State of the United States that for a compensation to be validly accepted, it should be prompt, adequate, and effective. Now, let's just try to incorporate or import this widely accepted customary international law of compensation to the Oromo land and the Ethiopian situation right now. There has never been a well-established adequacy and promptness, and also just and fair compensation paid for the Oromo farmers. They were arbitrarily dislocated without any due process of the matter. So the expropriation in this situation is automatically illegal and unconstitutional. That's how I see it. And the third important prerequisite for expropriation to happen is that it should follow a due process of the law. It's not something that a local officer or a local political cadre would come and tell you to leave the land that you've lived on for a long time. There has to be appropriate proceeding and settlement procedure through which fair principle of due process is respected, and all aspects of assessment of the value of the land, not only the current market value, but the future market value of the land should be considered in the due process of settling the expropriation problem. So when you just see that in light of what's happening now, the government arbitrarily takes away and snatches away the land from the poor Oromo farmers and resell that land to its own foreign or local close economic allies or economic elites. Now, having said that, one of the last points that I want to really make is how can we see the act of expropriation within the tradition of Oromo? For Oromo, land does not have only a market value. It does have an existential value. Now, does any amount of compensation satisfy or fulfill the Oromo fulfill the Oromo understanding of existential value of the land? I do not think so. For Oromo, as the saying goes, dubbi lafa, dubbi lafeti, which means the only property that the Oromos have is the land that they can flourish their life on. And can a market assessment of monetary damage be fulfilling and satisfying to the Oromo? That is the question that can easily be answered by average and ordinary Oromos. And I do not think that if you expropriate the land away from the Oromos, any amount of money would never satisfy that. So the right of expropriation of the Ethiopian government has to be seen in this very narrow room of taking away land. So the fact that we have to make this clear, the fact that the land, some people randomly say, oh, the land belongs to the government can't take the land away anytime it wants. No, it does not. The constitution puts that the land belongs to the common property of national Ethiopia. That means that the land is owned by the people. And you cannot simply get rid or get away people on the land and then take it away. That is what the inherent and constitutional understanding of that particular provision of the law provides. And that's how I see it in this situation.
Dr. Tsegaye.
May I add, it is very interesting that when last year we contested the constitutionality of the master plan, I think unwittingly we set the terms of argument, debate over the subject matter. And recently there came an article that argues that the master plan is constitutional, and I thought it was a direct speech back to me. And one of the arguments that is raised in this it is constitutional thing is that the land belongs to the state. Let me be very clear about that. I have before me Article 40 of the Constitution, which talks about the right to property, and this is what it says. First, the rights of every Ethiopian citizen to own private property is guaranteed. Unless the law provides otherwise in the public interest, these rights shall include the right to use, just a minute. The right, this right shall include the right to use and enjoy property, and insofar as it does not violate the right of others to sell, transfer by succession or by any other means. But this is not the most important part I wanted to refer to. Article 40 sub 3 says the right to own rural and urban land as well as natural resources belongs only to the state and the people. The state and the people and the state are conjoint owners of the land. And secondly, land, it says, is an inalienable common property of the nations, nationalities, and peoples of Ethiopia. Inalienable property. It is owned commonly, jointly by the state and the people, but it is an inalienable property of the nations and nationalities and peoples of Ethiopia. Now, this clause seems to speak back to the history of land alienation that happened especially during the imperial conquest of the land that is on the periphery of the Abyssinian core. And number 4, it says the right of Ethiopian peasants, and this is very important to the subject we are talking about, the right of Ethiopian peasants to free allotment of land and not to be evicted therefrom is guaranteed. Not to be evicted therefrom is guaranteed. Particulars for its implementation shall be determined by law. Now, this is very, very important to me, because if this master plan is going to be implemented, because it involves eviction, the terms of eviction should have been circumscribed by a specific law. And that didn't happen. And in fact, the fact that they didn't make it legally, and now there are so many official documents coming from offices. The one I have in front of me is a document that is coming with the seal and with the mark of the project office. It's a government document. It's official, but it's not legally binding, because all these terms of expropriation, eviction, in other words, land grabbing, are not, their scope is not circumscribed by any law. So there is a recognition in the public law that land is a joint property of the state and the nation, the peoples, that land is a property of nations, nationalities, and peoples. But there is an appropriation of the land privately by the private owners. And it's privately, I say, because it is not made publicly through law. And then it says, this is Article 40 sub 5, it says, without prejudice to the right of ownership of land by nations, nationalities, and peoples of Ethiopia. Mark this now. No matter what the circumstances, nations, nationalities, and peoples' ownership of land, property ownership, land as a property, cannot be trumped by any other interest in property. So it says, without prejudice to the right of ownership of land by the nations, nationalities, and peoples of Ethiopia, the state shall guarantee the right of private investors to the use of land upon payment of money, the amount of which is to be determined by law. Particulars, it says, shall be determined by law. Now, did we have any law on this? It's like in Ethiopia, one of the interesting things after this in this dispensation, post-Derg dispensation, is there is a rallying cry for pronouncement, a legal pronouncement on minimum wage. And there is a rallying cry on a legal pronouncement on a minimum compensation for land from which people are evicted. That has never been legally enunciated. Using the absence of law strategically now, these special interest groups and the government, which privileges that particular group, are actually acting in the absence of this law arbitrarily to evict the population and literally enforce selfishness of a particular economic interest group. Now you can ask your follow-up question.
Well, that was basically what I was going to ask you. I mean, about legal concepts at the conceptual level. That is, when one says it's a joint property of the state, and it says a common property of the nations and nationalities and peoples of Ethiopia, it looks like the problem arises when you operational those legal concepts. And what I was going to ask you is about, is it legally, at the conceptual level, is that a problematic concept when the pronouncements are made that it's a joint property, it's also a common property, it's the state, and also the Constitution also mentions that the federal government has the jurisdictional right to devise policies, developments, and investors, and at what level and in what context would the federal government's right trump the ownership rights of the states and the nationalities and the people? Is that legally, this is a problematic concept, right? That when it is a joint property, it says, I mean, what does that really mean when it's a joint property of the state and it's a common property of the people? Who really owns the land? Is that the federal government? Is it the state government? Is it the individual? Is that legally, is that a confusing concept?
It is. I mean, there is an obvious ambiguity about this. And the ambiguity comes from the fact that it might mean both things. You know, one of the things it says is that the land belongs to the state and the people. If you look at that phrase, I mean, clearly, if you approach the text closely, one of the things it says is belongs only to the state and the people. That statement is more about whom it doesn't belong to rather than whom it belongs to. What it is actually saying is that natural resources, urban and rural land, do not belong to individuals. That's what it is saying. It belongs to the state and the people. They have a direct, rightful ownership. That's what it says. Now, this is not very clear. Why is it that the very first article in Article 40, the very first section, talks about the right of private property, and yet here there is this strategic ambiguity put in the law? The reason was the time when the Constitution was made. What was the time? It was a post-Derg time, after the collapse of communism. It was a time of liberal triumphalism. It was a time of America influencing constitution making in the interest of what was then called transition to democracy. Ethiopia The EPRDF then was a very important upcoming client of the American government. And so the private property thing concerns them. So as a matter of securing legitimacy there, they just make a lip service in the first section by saying it's a private property. But then you have these entrenched, intractably strong statements without prejudice to, etc., talking about the fact that the land is a state property. Why do they want to say it is a state property? Because they can't deal with, denationalization that the Derg has done already. So they just want to keep that status quo, number one. Number two, they want to inflict that state ownership and get it back to the nations and nationalities and peoples on behalf of whom this revolution, this dispensation was put in place in the first place. So this is the newest form of gaining state legitimacy, the nations, nationalities, and peoples, the politics of recognition. So they bring in the people. Now, that is a very radical act, by the way. And that's one of the things we see as the undelivered promises of the Ethiopian constitution. It's a very radical act because it speaks back to history of alienation. And it is also very interesting that they recognize these nations, nationalities, and peoples, which are anthropological entities really, become a subjectivity, and owners, legal owners of a particular territory that they are in. Now, one of the problems legally, technically, about Ethiopian law, and I've dealt with this at length in different writings, is that legal personality comes in two forms in the Ethiopian law. One is the natural personality, the category of natural persons, where a person is a subject of right from birth to death, according to Article 1 of the Civil Code. So a person is recognized as a person, as a human person, as a legally intelligible person, if beginning from birth and death. The second kind of personality is called what is called legal personality, which is basically in corporations or charities or different other entities created by legal fiction, juridical persons and natural persons. One of the problems that intellectuals, the scholarship and the legal profession hasn't confronted yet is this third category of legal personality called nations and nationalities and peoples. Now, this terminology is got an ideological under and overtone. This terminology is not very clear at many levels. But there is this terminology is also demonized by left and right of the Ethiopian establishment intellectual class. The reason is the interest in denigration and invisibilization, if you like, of these other peoples of Ethiopia who have always been inhabiting the periphery of the political community. So, added to, taking all this into account, the category of persons called the nations and nationalities and peoples as recognized in the constitution, and which is important in the conception of the Oromo personality and the personality of the Oromia government and the Oromo nation, by the way. The fact that this is a black hole now, a legal black hole, which is undefined, which is only a kind of political catch-all phrase that the government uses to legitimize its own activities, especially vis-a-vis the old, centralized unitarist intellectual and political class. This problem is now making it very difficult to understand what it means to have these groups having property ownership over natural resources, urban and legal rural land. So this is the point I wanted to add, and then I'll go into the other. Now, the ambiguity, though, has been strategically used by the government. It wasn't an innocent ambiguity, it's not just something intellectually problematic concept that you find there. It is not an innocent ambiguity. It is politically manipulated. It is strategically used and deployed, rather cynically and in a sinister way. And it is high time now we bring out what the meaning of this third category of personality means in the Ethiopian legal language, and try to counter this mystification and or simplification, if you like, of the notion of state property, land as a state property or a public property, etc. The other difficult problem you raise is the issue of common property or joint ownership, etc. I mean, the reason why state and people are together presented as owners is basically, if you ask me, it's a legal laziness. I mean, the draftsmanship laziness. I mean, land was state property since 1975 by the Rural Land Proclamation, and they didn't want to undo that and create havoc around. So they want to keep the fact that it is state-owned, but then they want to bring in the people that are now valorized because of the ethno-federal dispensation.
I think there is more point that I just really want to reaffirm what Dr. Tsegaye said now, is I just really want to bring into light the market operation or the market system into this equation, because what we're dealing with is a very complex and highly complex issue of land and the market. There is a tendency from the government side to make the Oromo anti-market and anti-development. But what we have to ask really here is the point of the private property right, as the private property right of the Oromo themselves. As much as an investor has a right to private ownership, and also the Oromo people do have that property right as well. What has to be understood in this light is we're living in a world where everything is dictated by the market and global and domestic flow of investment in and outside of a country. And also we understand that the Oromo are not an exception to the global market activity. And neither should the Oromo be the victim of the market at the same time. And that has to be the point, that should be the point that has to be clear to both the government and also the foreign investors who want to come to Ethiopia and do their own investment. And the Oromo should be part and parcel of the market, and importantly should be the captain of their own market destiny. In doing so, what we have to underline in a very strong legal statement is that as much as anybody would claim a legal right to property on the land, so as the Oromo people also have the right to property on the same land that they have lived forever. So it is really difficult and perplexing to see the government trying to portray the Oromo as anti-market and anti-development on their very own land. So that when we talk about expropriation and the market flourishing and investment activities and infrastructure and integrated development, the first thing you have to ask is the right to property. And do the Oromos have the right to property? Yes, of course. And that is what I think the discourse should also be revolving around, is that the strong right to property should also be protected for the Oromos as much as it is protected for any investor, whether local or foreigner. And that's the point I just really want to add to what Dr. Tsegaye said.
The discussion has revealed to me, at least, that the Constitution in the making itself was not made under the veil of ignorance, but having people and other strategic interest in mind. But that's a problem or a legal quandary of its own.
Yeah.
But there is the other side of this master plan, that is the protests. And I really like us to talk before our time runs out about the rights to protest against policies. Now, Part 1 and Part 2 of the Constitution enumerate extensive human and democratic rights of the people of Ethiopia, or the citizens of Ethiopia. That includes the right to oppose policies. And out of the demonstrators, the protesters within the Oromia state, were they within their rights to conduct peaceful disapproval of both the master plan and the potential implementation of the master plan? Henok, we could start with you.
May I just before we pass on to that one, may I answer one question I left unanswered from the last part, which is about the federal-state relationship on the issue of land? May I?
Please.
Yeah, it is true. The federal government, it says in the section of the Constitution where it talks about the division of power between the federal government and the state government, and when it lists the power of the Federal House of People's Representatives, it talks about the fact that policy making, the power to make policy over land belongs to the federal government. But the power to administer land and natural resources, belongs to the state governments. So there is a division. There is a policy power at the federal government level, and there is administrative power at the regional or state level governments and local level governments. And that's as it should be. Even when the federal government, because of historical legacy, is also a co-owner of the state, the land as a property, it can't really administer it because the federal government really does not have a direct relationship with anything such as land. The result is it has only a policy power, a general direction framing power, and the state governments have the administrative power. What does that mean? Administration means they have the preponderance in making rules and regulations and directives about the specific plots of land, licensing, registration of deeds, determination of even compensation, because they are the ones who know exactly what kind of land is of what kind of value it has, etc., etc. Who know their farmers, who know the market value of the surrounding situation, and so on and so forth. So normally, administrative technical things such as master plans or evictions that come about from implementation of master plans, or designing master plans that develop particular towns, etc., should have been under the jurisdiction of the states. And that is as it should be, because we are a federation. Now, that has not been done, and it's like the states almost are invisible, do not exist, when they brought this from the federal government and the city, the Addis Ababa city, the only visible actor, which wants to go ahead and administer the rural land of Oromia towns. Now, why is this particularly of interest to them? Because for a number of years, and this has to be mentioned in this process because it's very much part of the protest and everything, for many years, the Oromia government has been trying to assert itself in the realm of administration of the rural land in those territories as well as in its own entire region. They've got their own environmental laws. They have very radical, very progressive environmental laws in the Oromia region. For all that we condemn OPDO, by the way, they have been the government there, willy-nilly, and elected, and etc., whatever. They have been making radical environmental laws. For example, forest laws, forest management laws. They make their laws to protect their forests, and most of the times, people who destroy forests in the Oromia region run away to the neighboring regions or run away to the city. And they say, we are not under your jurisdiction because we don't want to face the penalty that you have come up with. And they say, in fact, you can't make laws on forest, you can't make laws on land, and so on and so forth. That was one problem. And secondly, the Oromia government, especially with regard to these cities, it's very interesting that you notice now. In 2003, there was the Addis Ababa City Charter. According to the charter, the boundary of the city could be modified, meaning expanded, by the federal government unilaterally, by an agreement between the federal government and the Oromia region, by an agreement between the Oromia government and the federal government. And that created a lot of pain among the OPDO officials in the Chape Oromia. And you know what happened? They said then, number one, these things have to be corrected. Number two, our special interest in the city, according to Article 49.5, that has to be incorporated in this charter. And the government said, and interestingly, it is Abai Tsegaye himself who was behind that bill as a federal minister of federal affairs. He said, they were shocked actually. They said, oh, okay, we'll refer this law, this bill, to a second reading, and the next day it was proclaimed. And the OPDO had to be experiencing the first bite of humiliation. That was point number one. Since then, the issue of federal, then they were removed from the city, they were brought back to the city. In 2006, they wanted to have the special interest thing clarified. They wanted that the federal government to clarify that. Interestingly, the things that many people don't know, the Oromia government at some point, in fact, have tried to draft a bill which is on the constitutional special interest of Oromia over Addis Ababa. They have a draft bill. It's a very poor, weakly designed law, very soft and accommodative of the interest of the city and the federal government. But they came up with this, and it was rejected. What did they say then? Well, it is the federal government that has to issue the special interest law. They said, okay, issue it for us then. They didn't do that. And then what did the Oromia government do? Abadullah, so the Oromia government actually came up with this plan. Because Sululta, Aleltu, Sandafa, and all these cities, Lagatafo, etc., were in North Shore zone of Oromia. Sabata, Burayo, and so on and so forth. These were in the Western Shore zone of Oromia. And then there was the Eastern Shore zone of Oromia, which is the Dukam, Galan, and so on and so forth. Chapedonsa, all these places. So what did they do? I mean, because they are run from Adama, from Fiche, from Ambo, they had little control over the expansion into the Oromia region of the city government. So what they have to do was, Abadullah has to sit down and come up with a legislation in 2009, which establishes these waradas and zones as a special zone, so that it's got its own government that governs this area and asserts itself as a local government in its interface with the federal government and with the city government. One of the things it did, it's a very radical thing again. Now, in this, at least we need to give credit to where it belongs. One of the things they did is to create these cities as really cities and govern them by mayors, which is very radical, which has never happened before. Why did they want to do that? They want to have to make sure that the cities have their own administration governed by the mayors, and then the warada should be administered by the warada elected officials from the city. Doing this, they can address the issue of the urban people, the problems of the urban people. They also can address the problems of the rural people through the waradas. And in this way, they can counteract the expansion of Addis Ababa through a legal mechanism. The reason why the federal government now is asserting itself without even abusing, in fact, exploiting the legal ambiguity of the constitution now, is to liquidate all this emerging self-assertion from the part of the government of Oromia. And so by doing this, the right to administer land and natural resources by Oromia, by the states generally, is liquidated, and unconstitutionally, the federal government goes beyond its policy power, beyond its lawmaking, policy-making power, and does involve in such very local technical issues such as master plan. And that is simply indefensible constitutionally. And that's the point I wanted to add before we go on to the discussion of the protests. I'm sorry I took some time.
That's very helpful. Henok, the question is about the human rights and democratic rights. People could oppose the government on policy issues, whether that's the federal government or the local government. Were the demonstrators within their rights to oppose government, were they exercising their human, constitutional, and democratic rights?
That is absolutely right. Here, what has to be made clear is the right to demonstrate and peacefully protest against any policy that has been made to affect your own life. It is not only within the constitutional boundary, it is a natural and inherent